Hello everyone, and thank you for joining me today. As a pharmacy technician, you are probably familiar with the acronyms HIPAA and PHI. They affect the confidentiality of patient medical records, including prescription records. As professional healthcare workers, and even as patients ourselves, we know the importance of keeping personal health information just that, personal. So maintaining patient privacy and safeguarding protected health information is of utmost importance in our profession. In this presentation, we will become familiar with HIPAA, the Health Insurance Portability and Accountability Act, and Protected Health Information, PHI. We will also talk about the basic concepts and requirements of HIPAA. We will discuss the who, what, why, and how of this government-mandated law. We will learn to be HIPAA compliant in the pharmacy on a daily basis when communicating with patients to maintain confidentiality. We will also identify the key elements of the privacy rule, and we will also identify the information contained in the Notice of Privacy Practices, including why it must be signed and when and how it is received. So first, let's just go over a little bit of the history of HIPAA. HIPAA was enacted as a broad congressional attempt at healthcare reform. It was initially introduced in Congress as the Kennedy-Kassebaum bill, and on August 21st, 1996, Congress enacted the Health Insurance Portability and Accountability Act, which we now know as HIPAA, and it required the Secretary of Health and Human Services, which is also abbreviated HHS, to propose standards protecting the privacy of individually identifiable health information by August 21st of 1997, which was 1 year later. So covered entities, which we will go over a little bit later in the presentation, had 1 year to comply with the Health and Human Services to get to those standards. So now that we've went over the background of HIPAA, what exactly is it and what is the HIPAA privacy rule? Well, the Department of Health and Human Services Office for Civil Rights, which you'll sometimes see abbreviated as OCR, it enforces HIPAA's two main rules that it's composed of. So the first rule, the HIPAA privacy rule, provides for the privacy of an individual's personally identifiable health information. The second rule, the HIPAA security rule, establishes standards for the privacy of electronic health information. HIPAA protects customers from having their health information unnecessarily disclosed. Because of these rules, you have a right to see your health records and the right to copies of your health records. There may be a charge for copies of your records, or they may be free. It just really depends on the provider. But you're required to be given a notice of how your information will be protected, used, or shared. This notice is called the Notice of Privacy Practices, which we'll talk about a little later. And under these two main rules, you also have the right to file a complaint with your insurance company, with a doctor, or even with the U.S. government. Now, the rules of HIPAA are always being strengthened, and there's always amendments to the first rules that came out back in 1996. And recently, this year, in January of 2013, the final HIPAA Omnibus rule was published. The new rule expands patients' their individual rights under HIPAA, and by September 23rd, 2013, the rights must have been added to the Notice of Privacy Practices that providers give to the new patients. So, for example, patients can ask for a copy of their electronic medical record in an electronic form, and they can also instruct their provider to restrict disclosures to a health plan concerning treatment for which they've paid out of pocket in full. Further HIPAA modifications to this rule also strengthen the Health Information Technology for Economic and Clinical Health Act, which is also abbreviated HITECH, and we'll go into that just briefly a little bit later too. But this final omnibus rule also gives the Health and Human Services Office for Civil Rights expanded authority to pursue complaints about HIPAA violations, including civil and criminal punishments. So basically, covered entities that don't comply with the Health and Human Services, as far as when they ask them for information about their HIPAA rules, they will be fined for those actions. And just one more thing to note, the changes that strengthen the HITECH Act as far as the breach notification requirement, before it wasn't really clear about when you would have to report information to Health and Human Services as far as a breach of PHI, personal health information. So now you have to report anytime there is a breach of PHI, whether you think it's harmful or not. Now you have to prove that it's not harmful, where before you could just notify them if it was harmful, but now it's the other way around. You have to prove that it's not harmful. So who are the ones that have to comply with HIPAA and who have to worry about breaching our information to the public or to someone who doesn't need to know about it? So basically, HIPAA requires compliance by healthcare providers such as doctors, hospitals, clinics, and nursing homes, health plans like insurance companies, HMOs, company health plans, Medicare and Medicaid, and also healthcare clearinghouses. These are referred to as covered entities under HIPAA regulations, which means they are covered by the law. And business associates are persons or entities that perform certain functions that involve the use or disclosure of personal health information on behalf of a covered entity. So if you ever go on the Health and Human Services website, which is the most up-to-date information that you can find on HIPAA, you'll see sometimes there's a lot of covered entities and business associates, and it can get confusing if you're not sure which is which. So that's just to let you know which is which when doing any research. So HIPAA doesn't cover all organizations which may have some of your medical information, and it doesn't protect your information held by life insurance companies, employers, schools, or workers' compensation carriers. And it also exempts state agencies, municipal offices, and law enforcement agencies. So why exactly do we need HIPAA? Well, because so many people can have access to your personal information, Congress mandated the establishment of federal standards for the privacy of individually identifiable health information. The privacy rule established a federal floor of safeguards to protect the confidentiality of medical information. State laws provide stronger privacy protections and will continue to apply over and above the new federal privacy standards. Before HIPAA and the privacy rule were enforced, personal health information could be shared without notice or authorizations for reasons that had nothing to do with a patient's medical treatment or healthcare reimbursement. So, for example, an employer could make a personal decision about an employee based on personal health information, like if the person had HIV. So I keep mentioning protected health information, which is abbreviated PHI. So again, what is PHI? Well, according to the U.S. Department of Health and Human Services Information and Technology Improvement website, PHI is information that can relate to the individual's past, present, or future physical or mental health condition, and the provision of health care to the individual, or the past, present, or future payment for the provision of health care to the individual. The privacy rule protects all individually identifiable health information held or transmitted by a covered entity or its business associate, and it can be in any form, electronic, paper, or oral. It can include financial and demographic information collected from patients. So here's some examples of PHI. Now, don't confuse personal information with protected health information. Identifying information like names, addresses, and phone numbers aren't necessarily PHI until they're linked to the person's health information. So we as technicians know that we get this information from the patient's profile, so it's almost always considered PHI. Things like diagnosis codes, or a social security number, a health plan ID number, or their name, address, and birthday. These are all linked in their profile and are considered PHI. And as a good rule of thumb, if it's in their profile and if someone's asking you information, if you feel uncomfortable sharing it, then you probably shouldn't. So it's always best to double check with the pharmacist, but Again, if it doesn't seem right, then it's probably not. The minimum necessary standard, a key protection of the HIPAA privacy rule, is derived from confidentiality codes and practices in common use today. It is based on sound current practice that PHI should not be used or disclosed when it is not necessary to satisfy a particular purpose or to carry out a function. The minimum necessary standard requires covered entities to evaluate their practices and enhance safeguards as needed to limit unnecessary or inappropriate access to and disclosure of PHI. The privacy rules requirements for minimum necessary are designed to be sufficiently flexible to accommodate the various circumstances of any covered entity. The minimum necessary requirement does not apply to uses, disclosures, or requests by a healthcare provider for treatment purposes, uses or disclosures made to the individual or the patient, or uses or disclosures that are authorized by the individual pursuant to a valid authorization signed by the patient or a personal representative, so long as the uses or disclosures are consistent with the authorization. So basically, if a patient has signed an authorization and the person that they've authorized to give information to calls you, you wouldn't have to worry about the minimum necessary requirement, as they've already have given their authorization for you to speak to them on their behalf. The Department of Human and Health Services does say that they will continue to monitor the workability of the minimum necessary standard and consider proposing revisions where appropriate to ensure that the rule does not hinder timely access to quality health care. So before I said that we would touch on the notice of privacy practices, so under the privacy rule, covered entities must provide patients with a full notice on how their protected health information is used, disclosed, and protected. This notice of privacy practices specifies patients' rights and covered entities' responsibilities. The notice should include the header required by the privacy rule and should explain in plain language how the covered entity may use and disclose PHI about the individual's rights with respect to the information, and how the individual may exercise these rights, and must include how to file a complaint with the covered entity or with Human Health Services. The covered entity's legal duties with respect to the information, including a statement that the covered entity is required by law to maintain the privacy of the individual and must maintain their privacy of protected health information. So that must be included in there also. In that notice, individuals are told how they can get more information about the covered entity's privacy policies. The notice also must include an effective date and contains the wording, "This notice describes how medical information about you may be used and disclosed and how you can get access to this information. Please review it carefully." It also describes the types of disclosures to be made with and without patient consent or authorization. Patients are not required to sign the privacy notice if they don't want to, but if they don't sign it, it's your responsibility to document the refusal and the reason for not signing, and you have to keep it in your records for 6 years unless your state law requires longer. This is also the same length of time that you are required to keep all HIPAA consent. Now, this is just the main points that the Notice of Privacy Practices touches on. So if you've ever gotten one, it's really long, but this is basically what the information is saying. So when and how is the notice received? Well, the notice is received at a patient's first encounter in the pharmacy. In emergency treatment situations, the provider must give the patient the notice as soon as possible after the emergency. And it's also given to anyone who asks for it. It must be available on any website it maintains that provides information about its customer services or benefit. So a health plan must give its notice to each new enrollee at enrollment and send a reminder to every enrollee at least once every 3 years that the notice is available upon request. A health plan can give the notice to the name insured, which is the subscriber for coverage. It does not have to give separate notices to any covered spouses or dependents of that same subscriber. The notice may also be emailed to the patient if they agree to receive an electronic notice. So now that we've talked about the notice of privacy practices, I did mention authorization and consent. A lot of times people get them confused because they are similar, but they're not exactly the same thing when it comes to HIPAA. A consent is a general document that gives healthcare providers, which have direct treatment relationship with the patient, permission to use and disclose all PHI for treatment, patient, and healthcare operation purposes. It gives permission only to that provider and not to any other person. Healthcare providers may condition the provision of treatment on the individual providing this consent. One consent may cover all uses and disclosures for that provider indefinitely. A consent does not need to specify the particular information to be used or disclosed, nor the recipients of disclosed information. Only doctors or healthcare providers with a direct treatment relationship with a patient are required to obtain consent. Generally, a direct treatment provider is one that treats a patient directly rather than based on the orders of another provider, so if you were referred to that doctor. Other healthcare providers, health plans, and healthcare clearinghouses may use or disclose information for treatment, payment, and healthcare operation purposes without consent, or they may choose to obtain a consent. So in contrast, an authorization is a more customized document that gives covered entities permission to use specified PHI for specific purposes, which are generally other than the treatment, payment, and healthcare operation, or to disclose PHI to a third party specified by the individual. Covered entities may not condition treatment or coverage on the individual providing an authorization. An authorization is more detailed and specific than a consent. It covers only the uses and disclosures and only the PHI specified in the authorization. It has an expiration date, and in some cases, it also states the purpose for which the information may be used or disclosed. All covered entities, not just direct treatment providers, must obtain an authorization to use or disclose PHI for these purposes. For example, a covered entity would need an authorization from individuals to sell a patient to a mailing list or to disclose information for eligibility for life insurance. A covered entity will never need to obtain both an individual's consent and authorization for a single use or disclosure. However, a provider may have to obtain consent and authorization from the same purpose for different uses or disclosures. For example, a provider under the consent obtained from the patient send an appointment reminder to the patient, but would need authorization from the patient to send their name and address to a company marketing a supply service. Now, we've talked about authorization versus consent and when you can authorize your information to be disclosed, but can PHI be disclosed without authorization? Well, yes, it can, but only under certain circumstances. So in the example of law enforcement, there are a couple of examples. So in judicial proceedings, the rule recognizes that the legal process in obtaining a court order and the secrecy of the grand jury process provides protection for the individual's private information. In reports of abuse or neglect, in child abuse, it can be reported to any law enforcement official authorized by law to receive such reports, and the agreement of the individual is not required. In the case of adult abuse, neglect, or even domestic violence, it may be reported to law enforcement officials by law that can receive such report, and that's based on the exercise of professional judgment that the report is necessary to prevent serious harm to the individual or to others, or in certain emergency situations. Now, PHI can be disclosed when a person is a threat to public safety. Being a threat to public safety can also include someone who's appeared to escape from lawful custody. For activities involved in preparing for research, covered entities may use or disclose PHI to a researcher without an individual's authorization. However, they must prove that the use or disclosure is requested solely to review PHI as necessary to prepare a research protocol or for similar purposes preparatory to research. They also must state that the PHI will not be removed from the covered entity during the entire course of review, and that the PHI that they're requesting is necessary for the research. Now, disclosures of protected health information to law enforcement can only be made in response to written requests unless state law requires otherwise. And as far as activities for research, the covered entity may permit the researcher to make the representations in written or oral form. So those are just a few examples where PHI can be released without an individual's consent or authorization. But now let's talk about some individual rights that you and I and patients have. So they have a right to specify who can pick up their prescriptions. So I know that sometimes in a patient's profile in the pharmacy, we see that it says do not release information to so-and-so, or it will specify that this person is allowed to pick up a patient's prescription, especially if the patient's in assisted living or in a nursing home. A lot of times we see that authorization on file. Patients can also elect to pay out of pocket for prescriptions and not share information about these prescriptions with their insurer. So if a patient is coming to the pharmacy to get prescriptions for an illness that they don't want their insurance company to know about, they are allowed to do that under the HIPAA privacy rule. So you need to take precaution when releasing any information to an insurance company to make sure that you only give the insurance company the minimum necessary information, and make sure that you don't release any information about a cash prescription that they've paid for. And if that's the case, just make sure that if any prescriptions are paid in cash, that it's documented in the patient's record, just to prevent that PHI from being released. And also, patients can request a copy of PHI in an electric format and designate where it can be sent to. So if the covered entity has an electronic form, it can be requested by the individual if the form is readily producible. If it's not, then they must provide access in another readable electronic form agreed to by the covered entity and the individual, like a Word document or a PDF file, something along those lines. The patient may also direct the covered entity to transmit the electric copy directly to a designee that the individual assigns. So the request must be in writing, signed by the individual, and must clearly identify both the designee and where to send a copy of the PHI. So here were just a few more bits of information that I found that I thought would be helpful regarding PHI. So the disclosure of immunization records to schools or daycares is okay without written authorization. Before, it was previously required, but these days most schools and daycares require their students to be vaccinated, so they're allowed to get those records. Health information about deceased patients is allowed unless the patient previously expressed other preferences prior to their death. So unless the covered entity knows that disclosing any health information would be inconsistent with the decedent's previously expressed preferences, then releasing that information is okay. The amendment of the rule also removes all protections on PHI of persons who have been deceased for 50 years. And the last thing I found that I thought would be helpful was that health plans are prohibited from using genetic information for underwriting purposes like eligibility, premiums, or pre-existing conditions. So, for example, a health plan can't deny you coverage because your mom or your dad or your grandparents had diabetes. Healthcare providers may, however, use and disclose genetic information for treatment and other permitted purposes. Now let's move on to one of our objectives for the program, and that was to talk about the Health Information Technology for Economic and Clinical Health Act, which is also referred to as HITECH. The act was enacted to promote the widespread adoption and meaningful use of electronic health records, which are referred to as EHR, and related technologies. The HITECH Act stipulates that beginning in 2011, healthcare providers were offered financial incentives for demonstrating meaningful use of EHRs. The incentives will be offered until 2015, after which time penalties may be levied for failure to demonstrate such use. The Act also establishes grants for training centers for the personnel required to support a health IT infrastructure. The HITECH Act also requires covered entities to provide electric copies of PHI maintained in an EHR to the patient upon request, so once again allowing patients access to their medical records. It also states that any business associate that contracts with a pharmacy will now be held to the same privacy standards as the pharmacy and will be subject to the same criminal and civil penalties for any violations. So speaking about violations, let's talk about a breach. A breach is an impermissible use or disclosure under the privacy rule that compromises the security or privacy of PHI such that the use or disclosure poses a significant risk of financial, reputational, or other harm to the affected individual. Recently, there's been a change to the breach notification requirement. Previously, as I stated before, breaches only had to be reported if they posed harm to the patient, but now all cases of impermissible acquisition, access, use, or disclosure of PHI are presumed to cause harm and be reportable unless the covered entity or business associate can demonstrate that there was a low probability that PHI was compromised. So they have to prove now that the PHI that's been released is not harmful. So what happens if there's a breach of PHI? Well, covered entities must notify the affected individuals following the discovery of a breach of unsecured protected health information. Covered entities must provide the individual notice in written form by first-class mail or by email if the affected individual had agreed to receive notices electronically. These individual notifications must be provided without unreasonable delay and in no case later than 60 days following the discovery of a breach. It must include, to the extent possible, a description of the breach, a description of the types of information that were involved in the breach, the steps affected individuals should take to protect themselves from potential harm, a brief description of what the covered entity is doing to investigate the breach, mitigate the harm, and prevent further breaches, as well as contact information for the covered entity. Now, covered entities that experience a breach affecting more than 500 residents of a state or jurisdiction are, in addition to notifying the affected individuals, are required to provide notice to the media outlets serving the state or jurisdiction. Covered entities will likely provide the notification in the form of a press release to those appropriate media outlets. Like the individual notice, the media notification must be provided without unreasonable delay and in no case later than 60 days following the discovery of a breach. It also must include the same information required for the individual notice. In addition to notifying affected individuals and the media, if need be, covered entities must notify the Secretary of breaches of unsecured PHI. Covered entities will notify the Secretary by visiting the HHS website and filling out and electronically submitting a breach report form. If the breach affects 500 or more individuals, again, they have no more than 60 days to report it. If the breach affects less than 500 individuals, then the covered entity may notify the Secretary of these breaches on an annual basis. So now that we've talked about PHI and the Notice of Privacy Practices, Authorization and Consent, let's look at two scenarios to see if HIPAA has been violated. In our first scenario, Mary comes to pick up her 90-year-old mother's prescription. As you are cashing her out, she requests to speak with the pharmacist. She asks the pharmacist questions about the medication, and the pharmacist continues to counsel her on that medication. Has the pharmacist violated HIPAA? Well, no, the pharmacist did not disclose any personally identifiable protected health information about Mary's mother. The pharmacist counseled Mary only on the prescription that she was picking up. Discussing side effects and precautions with Mary does not violate HIPAA. If the pharmacist had mentioned a drug interaction with a medication that her mother was taking, it would then constitute a HIPAA violation. That was not the case here, and so no HIPAA violation occurred. In our second scenario, Mr. Clark's physician wrote a prescription for Diavan, a drug used to lower blood pressure. The pharmacy benefits manager, the PBM, kicks back the prescription because it is a non-formulary drug. The message he receives states that another antihypertensive drug, lisinopril, should be tried instead. Having reviewed Mr. Clark's profile, the pharmacist knows that he has taken lisinopril in the past and has developed a cough due to the medication. The pharmacist calls the PBM to ask for permission to fill the prescription for the Diavan. But the pharmacy benefits manager says that before they can get permission, they alert the pharmacist that they are collecting information about people with high blood pressure for a drug manufacturer. The agent begins asking the pharmacist detailed questions about Mr. Clark's medical history. The pharmacist willingly shares information from Mr. Clark's profile. So is this a HIPAA violation? Well, yes, because the pharmacist has gone beyond the minimum necessary to obtain payment for the Diavan. Under the privacy rule, he is allowed to contact Mr. Clark's PBM to pursue permission to fill the prescription and release the information that he had a reaction to the lisinopril. The information is necessary for payment. It would not be unusual for an insurance company to ask that a patient try a formulary drug, in this case lisinopril, before allowing payment for a non-formulary drug, Diavan. The pharmacist violated HIPAA by answering questions about Mr. Clark's medical information. So now that we've seen some examples of HIPAA violations, what are the consequences when these violations take place? Well, first of all, you could definitely be terminated by your employer, but there's definitely bigger stipulations than that. Violations in which the offender didn't realize he or she violated the act and would have handled the matter differently if he or she had, the result is a $100 fine for each violation, and the total violations cannot exceed $25,000 for the year. That's in the first tier. There's a few tiers that the consequences are broken up into. In tier B, the violations due to reasonable cause but not willful neglect, the result is a $1,000 fine for each violation, and the total fines cannot exceed $100,000 per calendar year. In tier C, where the violations were due to willful neglect, that the organization ultimately corrected, the result is $10,000 for each fine and not exceeding $250,000 for the calendar year. And the highest tier, which is tier D, is violations of willful neglect that the organization didn't correct. The result is a $50,000 fine for each violation, and the fines cannot exceed $1.5 million per calendar year. Now, it's not just covered entities who have to be HIPAA compliant. The business associates of covered entities are held to many of the same rules and are now liable for violations. Business associates are any entity that creates, receives, maintains, or transmits PHI. So this means that any company your pharmacy or office works with who handles PHI has to protect it as closely as you do, or as you can see, they'll face some pretty stiff penalties. So, for example, billing services, prescription software vendors, data archive companies, and companies that destroy used labeled protection vials have to be HIPAA compliant. And in addition, your pharmacy or office can be held liable for the acts of its business associate, and business associates can be held liable for the acts of their subcontractors. So it's a two-way street. The government will have more latitude to crack down on those who don't comply with HIPAA. So instead of slapping wrists and helping companies learn how to be HIPAA compliant, they'll be collecting these fines for violations found during investigations and audits. You'll see bigger financial penalties for HIPAA infractions and harsher actions when willful neglect is suspected. If you see activities that are questionable, report them right away, because the faster potential violations are addressed, the better. So as you can see, the consequence of breaking HIPAA regulations can be very severe. So make sure you do not leave any PHI lying around for others to see, and when you're speaking with a patient in the pharmacy, make sure you use a lower tone and speak away from other customers or patients so that they can't hear you. Now let's talk about some examples of the consequences that have happened in cases in the U.S. So back in 2009, the U.S. Department of Health and Human Services and the Federal Trade Commission, the FTC, announced that a large retail chain had to pay the U.S. government a settle and take corrective action to ensure that it didn't violate the privacy of its millions of patients when disposing of information such as identifying information on pill bottles. The settlement applied to all of their more than 6,000 retail pharmacies following an extensive investigation by the Health and Human Services Office for Civil Rights, OCR, for potential violations of the HIPAA Act of 1996 privacy rule. OCR, which enforces the privacy rule, opened its investigation of the pharmacy compliance with the privacy rule after media reports alleged that patient information maintained by the pharmacy chain was being disposed of in industrial trash containers outside selected stores that were not secure and could be accessed by the public. At the same time, the FTC opened an investigation of the pharmacy. The privacy rule requires health plans, healthcare clearinghouses, and most healthcare providers, which are all covered entities as we've talked about, including most pharmacies, to safeguard the privacy of patient information, including such information during its disposal. The HHS and FTC also require the pharmacy to actively monitor its compliance with the resolution agreement and FTC consent order. The monitoring requirements specify that the pharmacy must engage a qualified independent third party to conduct assessments of the pharmacy's compliance and render reports to the federal agencies. The HHS Corrective Action Plan was in place for 3 years, and the FTC required monitoring for 20 years. Among other issues, the reviews by OCR and the FTC indicated that the pharmacy failed to implement adequate policies and procedures to appropriately safeguard patient information during the disposal process, and that the pharmacy failed to adequately train employees on how to dispose of such information properly. So, in turn, under the HHS resolution agreement, the pharmacy agreed to pay a $2.25 million resolution amount and implement a robust corrective action plan that required privacy rule compliant policies and procedures for safeguarding patient information during disposal, employee training, and employee sanctions for noncompliance. In this second example, earlier this year, the court awarded a $1.44 million payment to an Indiana woman after a pharmacist inappropriately used her position to take and share her protected health information. The case included allegations that the customer's pharmacist accessed, reviewed, and shared the customer's prescription history with others who then used the information to intimidate and harass the customer. The pharmacist had accessed the data multiple times and given it to her husband, who was the customer's ex-boyfriend, who then texted her to tell her that he had seen her PHI. He used the information to intimidate the customer when she demanded child support payment. So, in turn, the customer filed suit against both the pharmacist and the pharmacy in an Indiana Superior Court, claiming the pharmacist and, in turn, the pharmacy had breached their statutory and common law duties of confidentiality and privacy. The complaint also included claims of negligence, invasion of privacy, and publication of private facts against the pharmacist, and claims of negligent training, supervision, and retention against the pharmacy for continuing to employ the pharmacist after discovering the incident. The pharmacy said, "The pharmacist in this case admitted she was aware of our strict policy and knew she was violating it. We believe it is a misapplication of the law to hold an employer liable for the actions of one employee who knowingly violates company policy." The way, however, the judge and jury interpreted the pharmacy's liability may have future repercussions. Clearly, the judge and jury were confident that the pharmacy had not done enough internally to prevent the pharmacist from snooping through patient files, such as implementing an internal user monitoring product. When the customer called the pharmacy to alert them of the breach, the pharmacist was still capable of accessing the data a second time. So what we learned from this case is that every HIPAA-covered entity needs to realize and reinforce to its employees that the privacy provisions of HIPAA are serious and have significant consequences if they are violated. So it wasn't just the pharmacist who felt the repercussions of what she had done, but the pharmacy also had to pay in turn. In this last example that includes hospice, for the first time, a federal investigation of a health information breach that affected fewer than 500 individuals resulted in a penalty for HIPAA violations. The OCR acknowledged in its statement that a stolen laptop contained protected health information of 451 individuals that were patients in the hospice center. That information included patients' names, addresses, dates of birth, social security numbers, diagnoses, medications, lab results, and other treatment information. OCR began its investigation after the hospice reported at the end of 2010 to Health and Human Services that an encrypted laptop computer had been stolen in June of 2010. The stolen laptop was assigned to a hospice nurse and part of an inventory of laptops used by nurses, social workers, and other workers for field work. The laptop was stolen from the employee's car while parked at her home on the weekends. The OCR investigation determined that the hospice had not conducted a risk analysis to safeguard electronic protected health information, and further, hospice did not have in place policies or procedures to address mobile device security as required by the HIPAA security rule. This case illustrates that no matter what the size of a breach, the Department of Health and Human Services Office for Civil Rights may impose penalties if its investigation reveals HIPAA noncompliance issues. So let's just review how we can stay HIPAA compliant in the pharmacy. Remember to reveal only the minimum necessary, especially when you're on the telephone. Just remember that you can talk to other healthcare providers treating a patient about that patient's case. When you talk to individuals not in a treatment relationship with the patient, but who are involved in the payment, like the insurance company, you just make sure you keep the PHI discussed to the minimum necessary to do the job. Also remember that when you're working at the counter or when you're at the drive-thru that you only reveal the minimum necessary. If a patient's prescription is ready, just say, "Mrs. Smith, your prescription is ready." Don't say, "Mrs. Smith, your penicillin prescription is ready," because then you will have violated HIPAA. Make sure to always give the correct patient back their correct insurance card and ID. The cards contain information that will be linked to their profile, so that personal information becomes protected health information. And make sure to always speak lowly if necessary to prevent other patients from hearing your conversation. You don't want passersby to be able to hear what you're talking about with a patient when it comes to their personal medical information. So, final thoughts. Always be conscious to safeguard protected health information. Always make sure that you're not leaving anything face up. Make sure a prescription is always face down after you scan it in. Don't leave things hanging around. Be careful with electronic devices that contain PHI. Misplacing one could put you, the pharmacy, or your practice and your patients at risk for a breach. And don't send unencrypted PHI over email or via text messaging because it's way too easy to intercept. If something doesn't seem right, ask. If you're not sure that you should be releasing information to an insurance company or to a doctor's office, just double check with the pharmacist. Let them be aware of what it is you're being asked to do or say. Most pharmacists and pharmacies are covered entities under HIPAA and will be held responsible for complying with the various federal rules. And as we saw, when you violate those rules, there are some hefty penalties involved. So make sure that you're complying with HIPAA. And finally, the golden rule: treat others how you want to be treated. So treat patients' personal information like you want your personal information to be treated. I know that we come across those patients in the pharmacy who just kind of tell us everything from what medical conditions they have to what medications they're on, but if they want to volunteer that information, then they can definitely go ahead, but just make sure that you don't volunteer that information so that you don't get caught violating HIPAA. Well, I hope that everyone has found this presentation helpful and as a good refresher.